when which
स्टडी आया इन्फॉर्म में
डेट बताइए ना, मरने का डेट बताइए।
तो इन्फॉर्म मिली
तो अजब बात,
बराबर के 2 महीना हो गया बीत गया।
ऐसे नंबर 206 of 2023 the letter transfer to Abdullah has submitted that corresponding number 2 has expired around 2 months now. Settlement. Post on 24th February. कब हो जाएगा? नहीं फाइल करिएगा कब हो जाएगा?
तो आगे तक हम लोग अगला मंडे को ही फाइल कर देंगे।
2 महीने से तो बैठे हुए ना।
कल ही हमको इन्फॉर्मेशन है। जब हम इन्फॉर्म इधर से किए
Item 22, second appeal 241 of 2023.
Please.
What is the
silent?
We have got on record and kept on record. And because the learned trial court as well as the appellate court, the lordship they have unanimously head exhibit 3, which is actually rent assessment. That is not covered. Covered is this one is the covered, which clearly shows.
यार जिस तरह से लगाए हैं ना, बताइए किस तरह से लगा के आप ओरिजिनल डॉक्यूमेंट फाइल करती हैं। एक तो उल्टा लगा हुआ है, दूसरा पूरा फोल्ड करके लगा हुआ है, इसको ना कोई खोलेगा ना तो देखेगा, कोई मतलब ही नहीं है इसका। आप मुंशी जो है ना, इसको एकदम बिल्कुल ही रेकलेस तरीके से लगा दिया। पहले भी नहीं फाइल किया
जी।
Why did you file earlier? क्यों नहीं फाइल? ये explanation
ये अंदर erroneous impression है बस। Exhibit 3 जो था, वो एक्चुअल में खबर समझ के फाइल हो गया था, लेकिन वो रेंट असेसमेंट है जो कि बिहार लैंड रिफॉर्म्स एक्ट में जो रेंट असेसमेंट होती है पार्टी के नाम से, वो दैट इज दैट डॉक्यूमेंट।
नया डॉक्यूमेंट आप
नया डॉक्यूमेंट हम सिर्फ कवर ला रहे हैं टू शो दैट दैट इज नॉट द कवर।
तो इसको एडमिट करिए तब ना रही
हाँ जी, दैट इज व्हाट दिस इज रिक्वायर्ड इन द इंटरेस्ट ऑफ जस्टिस।
नो
रिक्वायर्ड
इस तरह का डॉक्यूमेंट है।
लीव इट ओरिजिनल।
सुपर हम एडमिट नहीं करते हैं, ले लेंगे अपना आराम से वहाँ एडमिट कराते हैं। Why should I admit it like this? क्योंकि मोहर लगा हुआ है इसलिए ओरिजिनल है, इसलिए सही है, ऐसा बोलकर सेकंड अपील नहीं होगा ना, नहीं होगा ना।
फॉर्मल प्रूफ तो इसका सर्टिफाइड कॉपी ऑफ डॉक्यूमेंट है इसका फॉर्मल।
It has to be formal proof तो होगा कैसे नहीं? सर्टिफाइड कॉपी ऑफ द डॉक्यूमेंट कोई फॉर्म
सर्टिफाइड कॉपी ऑफ द डॉक्यूमेंट है।
क्या पता ये सर्टिफाइड कॉपी है क्या नहीं है, नया डॉक्यूमेंट आप लेके आ रहे हैं।
नहीं ठीक, दैट है।
कम से कम कोई आके ओरल एविडेंस के भी तो कोई एग्जिबिट करेगा, इसका रिबटल का भी चांसेस होगा, ऐसे थोड़ी हो जाएगा कोई आप।
नहीं हम तो पहले इसमें रिबटल का भी होगा, सब कुछ होगा और ऑर्डर 41 रूल 27 के लाइट में ही। इसमें एक्चुअल में मेरा केस ये है कि हम इसमें परचेजर हैं, हमने 2 रजिस्टर्ड सेडेड से हमने प्रॉपर्टी को खरीदा बाय वर्च्यू ऑफ रजिस्टर्ड सेडेड फ्रॉम द रिकॉर्डेड टेनेंट्स, और उसके बाद जो है हम पोजीशन में है, कुछ हमारा म्यूटेशन प्रॉपर्ली नहीं हो पाया था, लेकिन हमने अपने वेंडर्स का म्यूटेशन का जो कागज में लगाया। अदर साइड के क्लेम जो है एक अनरजिस्टर्ड हुक्मनामा से, वो भी जो जिस आदमी ने
आप रजिस्टर्ड हुक्मनामा किससे खरीदे?
हम नहीं लिया, अब तो मेरा रजिस्टर्ड सेलिड
किससे खरीदे?
सेलिड हमने खरीदा है।
नाम बताइए किससे?
हमने हरी बख्शी से खरीदा है और एक दानी सिंह से खरीदा है। 1 to 5 ने हरी बख्शी से खरीदा।
तो दोनों सहेली का कहानी एक साथ कैसे मिल सकती?
नहीं तो दानी सिन्हा भी रिकॉर्डेड टेनेंट के वारिसान हैं और हरी बख्शी मुरली मनोहर लाल प्रसाद के वारिसान उनके वारिसान।
रिकॉर्डेड टेनेंट कौन?
रिकॉर्डेड टेनेंट बख्शी स्वरूप नारायण लाल एंड अदर्स, ये ओरिजिनल पर्सन ही है। इनके ये सब वारिसान हैं और ये जो एग्जिबिट 3 है उसमें ये इनका नाम मेंशन है, जो कि रेंट असेसमेंट है, जो कि कोर्ट ने इसको कह दिया कि नहीं ये डॉक्यूमेंट जो है सो आपको इसे राइट नहीं।
आप लेंगे?
जी
आप लेंगे?
अपने
कॉर्पोरेट फाइलिंग,
कंकरेंट फाइटिंग
आपका केस कंटिन्यू,
जी
अपना ये जो जर्मनी में जो प्लेंटिफ का केस,
हाँ ट्रायल कोर्ट से पढ़ते हैं।
हाँ राइट,
Plaintiff 1 to 4 Paravan.
वो देखिए वो तो नहीं है सर। Parents,
Briefly stated, plaintiff's case as averred in the plaintiff that plaintiff 1 to 4 are the resident of village of Jharkhand and plaintiff number 5 is the resident of village right, Moja Kodal. It is stated that plaintiff 1 to 4 purchased 1.35 acres of land out of 2.71 acres pertaining to Khata number 100, plot number 297 situated in village Raiti, PS Markacho, district Kodarma from one Haribox by virtue of a registered sale deed 4604 dated 25/9/95 for available consideration and are coming in possession of the purchased land. Plaintiff number 5 purchased 69 decimals of land in plot number 297 out of 2.71 acres situated in Khata number 100 and also purchased 58 acres of land, decimals of land out of 1.16 acres appertaining to Khata number 100, plot number 298 situated in Gujarati, PS Markachu, district Kodarma from one Srimati Dani Sinha, granddaughter of the recorded tenant Ambika Pasha by virtue of registered sale deed 5742 dated 11/12/1995 for available consideration and has been coming in the possession of
yes,
the
recorded tenant with respect to both the properties is Ambika Prasad. ऐसा लग
नहीं,
रहा है।
अंबिका प्रसाद के अलावा
नहीं तो ये दोनों प्लेंटिफ नंबर 1 to 4 एंड प्लेंटिफ नंबर 5 का कहानी कैसे जुड़ी?
इसलिए कि तो एक जो रिकॉर्डेड टेनेंट है, जो मेन रिकॉर्डेड टेनेंट है जिसका नाम हमने पढ़ा वो एग्जिबिट 3 में मेंशन
ये एग्जिबिट 3 आप हमको ये बताइए आपका केस क्या है?
हमारा केस ये
You must be stating in your plaint that
हाँ,
who was the recorded
plaintiff
tenant.
बता, हमारा केस जो यही है कि हरी बख्शी और श्रीमती दानी सिंह दोनों जो कि हमारे वेंडर्स हैं, both are the recorded descendants of the recorded tenant. ब्रजनाथ सहाय और विश्वनाथ प्रसाद एंड अंबिका प्रसाद sons of स्वरूप लाल लाली लाल एंड मुरली प्रसाद sons of भगवान सहाय इन द रिविजनल इनके नाम से रिविजनल सर्वे रिकॉर्ड्स ऑफ राइट में इनका नाम सब इंटर्ड
इनका नाम विश्वनाथ प्रसाद एंड अंबिका प्रसाद
son of स्वरूप प्रसाद लाल एंड लाली लाल एंड मुरली प्रसाद sons of भागवत सहाय।
और ये हरि बख्शी से क्या लेना?
हरि बख्शी इनके इनके लड़के हैं।
कहाँ से पढ़ी?
आप बता रहे हैं, इसी में तो पढ़ रहे थे। हरि बख्शी फ्रॉम वन हरि बख्शी बाय वर्च्यू ऑफ रजिस्टर्ड सेल डीड पढ़े थे अभी हम पारा 2 में। पारा 3 में देखा जाए तो
पैरा 3 is plaintiff number 5 का।
हाँ पारा 2 में
plaintiff number 1
पारा 2 में
1 पैरा 4 हरि बख्शी vendor of plaintiff number 1 to 4 and Srimati Dani Singh vendor of plaintiff number 5 are the heirs of the descendants of Katyani Rayyan of खाता number 100।
और विश्वनाथ प्रसाद अंबिका प्रसाद सन ऑफ स्वरूप प्रसाद
कोई रिलेशनशिप ऐसा नहीं करता है।
नहीं रिलेशनशिप सब ये भागवत सहाय जो है और भागवत सहाय और इसके अलावा जो है इसीलिए हमने खबर
भागवत सहाय इसमें है नहीं।
नहीं भागवत सहाय लिखा है देखा जाए पाराफर पढ़ा जाए। The further case of the plaintiff is that Hari Bakshi, the vendor of plaintiff number 1 to 4 and Srimati Dani Singh, vendor of plaintiff number 5 are the heirs and descendants of Katyani Rayans of 100. It is stated that land appertaining to Khata number 100 was recorded in the name of Vishwanath Prasad and Ambika Prasad, sons of Swarup Prasad Lal and Lali Lal, and Murli Prasad, sons of Bhagwat Sahai in the revision sir. ये सब भागवत सहाय के हैं और वो अंबिका प्रसाद। तो रिकॉर्डेड टेनेंट में इसमें डिस्प्यूट नहीं है। इसमें डिस्प्यूट जो ये है कि अदर साइड का कहना क्या है कि एक मॉर्गेजी थे गुलाम हैदर जो कि एक्स लैंडलॉर्ड भी नहीं थे, ही वाज हिमसेल्फ ए मॉर्गेजी। उन्होंने इन्हें एक हुक्मनामा दिया एग्जिबिट भी, उसके बुनियाद पर ये क्लेम करते हैं। और मेरा नाम जो हम लोगों के वेंडर्स का नाम जो रिविजनल सर्वे रिकॉर्ड्स ऑफ राइट में जो एंट्री हुआ उसमें इनका कहना है कि उसके बाद इन्होंने एक सेक्शन 90 ऑफ CNT एक्ट में एक केस किया जिसके बुनियाद पर इनका नाम उसमें चढ़ाने का ऑर्डर हुआ और उसके बुनियाद पर भी ये क्लेम कर रहे हैं। लर्नेड कोर्ट ने रजिस्टर्ड सेल डीड को हुक्मनामा के आधार पर एक तरीके से डिक्लाइन कर दिया और उसमें ये इनका कहना है कि आप सेक्शन 90 का ऑर्डर नहीं चैलेंज किए। सेक्शन 90 का जो CNT का जो ऑर्डर होता है सबसे पहले 87 का एक्चुअल में होता है और सेक्शन 90 हुजूर देखा जाएगा इसमें सिर्फ मटेरियल एंड बोनाफाइड एरर का करेक्शन होता है। उस पर राइट टाइटल या कोई भी अदरवाइज आप उसमें नहीं उठा सकते। तो एक तरीके से सेक्शन वो भी एक एक्सपार्टी ऑर्डर भी हमारे वेंडर्स के खिलाफ, उसके बुनियाद पर ये राइट क्लेम कर रहे हैं। हमारा क्लेम बाय रजिस्टर्ड सेल डीड से है और हमने रेसिडेंट रिसीट्स वगैरह भी रिकॉर्ड पर लाया है और ये सारा पॉइंट हमने फ्रेम किया है जो आप इसमें हमारा पॉइंट ऑफ लॉ देखा जाए। पारा सी हमने लिखा है whether the learned appellate court while passing into judgment and decree committed serious error of law in putting blind reliance on exhibit I order dated 7/7/1975 passed in review case number 6680 of 1970 in overriding right title and position of the plaintiff which have been acquired by virtue of registered sale deeds and are in possession over the suit. Whether the learned appellate court while passing into judgment and decree committed serious error of law in relying on the exhibit B, the registered hukumnama, as it is completely failed to appreciate that the Ghulam Haidar Khan himself was a mortgagee and had no right to grant hukumnama, and zamindari receipt and the government receipts can have no sanctity in law and have no right title interest to the defendant by virtue of a purchased hukumnama.
कौन-कौन सा पढ़े
एक ये वाला जो ये है, whether the learned appellate court while passing into judgment and decree fail to constitute exhibit 3 rent or showing
नहीं,
name
आप ये तो नहीं पढ़े थे, आप कोई और पढ़े थे।
अभी अभी मैं पढ़ रहा था ये सी whether the learned appellate court by passing into judgment and decree committed serious error of law in putting blind reliance on exhibit I order dated 7/7/75 passed in review case number 66670 of 70 in overriding the right title and position of the plaintiff which they have acquired by virtue of registered certificate and are in possession over this suit. Whether the learned appellate court by passing into judgment and decree committed serious error of law in relying the exhibit B registered or registered hukumnama dated 15/8/38 as it completely failed to appreciate that the Ghulam Haidar Khan was himself a law.
आपके that the vendor necessarily interest उनका 3, 4, 5, 6, 7 में उनका रेट
हमारे नाम से म्यूटेशन नहीं हुआ, लेकिन हमने उनके नाम का म्यूटेशन रिसीट्स लाया है, एग्जिबिट्स 2 और वगैरह हमने इनका लाया है रिकॉर्ड।
रेट रिसीट लाए हैं तो उनका असेसमेंट का ऑर्डर लाए,
एक एग्जिबिट 3 असेसमेंट का ऑर्डर मिला है और वो उसको खेवट मान दी, खेवट मान करके जबकि रेंट जब जो भी
उसको खेवट अगर मान दी
जी।
है तो भी ऑर्डर कैसे करेंगे? रेंट रिसीट तो रेंट कोड तो है ही आपके नाम से,
उसमें डिस्प्यूट नहीं है। डिस्प्यूट इसमें मेन इशू ये है, अदर साइड का ये कहना है कि दे आर क्लेमिंग वर्च्यू बाय एग्जिबिट बी जो कि हुकुमनामा, और दूसरा उनका कहना ये है
तो सीएनटी करने से तो हो जाएगा,
सीएनटी के अगेंस्ट में ही करती, जबकि सेक्शन 90
नहीं सीएनटी करने से तो हो जाएगा ना आपका सब्सटैंशियल क्वेश्चन ऑफ लॉ इतना में तो हो जाएगा।
हाँ ना हो जाए, एक तो सीएनटी वाला भी एक तो हम करना चाहिए।
सीएनटी वाला तो है ही ना,
यहाँ एक इसमें है सीएनटी वाला अलग से फ्रेम बता।
यही तो सीएनटी वाला यही तो है, रेवेन्यू केस नंबर 6680 ऑफ 1970
सेक्शन 90 भी स्पेसिफिकली
यही तो है, सेक्शन 90 सी में ही तो है सेक्शन 90 का ऑर्डर, सी में ही है ना, राइट?
एक अलग से भी
तो कोई जरूरत नहीं है ना, सेक्शन 90 नहीं भी लिखा हो तो क्या
नहीं लिखा
देखिए सेकंड अपनी नंबर 241 और तो मैंने काम कर रहा हूं। This appeal will be heard on the following substantiation of law. C रहेगा and D रहेगा, पेज नंबर 16 and 17 में C को थोड़ा डिफरेंट करिए, ब्लाइंड आई थोड़ा ठीक नहीं लगता। Whether the learned appellate court, ट्रायल कोर्ट में आप भी करेंगे,
नहीं ट्रायल कोर्ट भी आ रहा है,
तो learned courts होगा ना,
कोर्ट्स
whether the learned courts by passing the judgments and decree committed serious error of law in relying on exhibit I, order dated 7/7/1975 passed in revenue case number 6680 of 1970. In overriding right, title and possession of the claim of right, title and possession of the plaintiffs, which they have acquired by virtue of registered sale deed, claimed to have been executed by the descendants of the recorded. So whether the learned courts committed error by relying upon unregistered hukumnama dated 15/8/1938 issued by one Ghulam Haidar Khan, alleged to be a mortgagee and that should be sufficient.
Yes.
Alleged to be mortgagee who subsequently issued zamindari rent receipt
In favor of
in favor of the contesting issue notice to the respondents for which refusals under ordinary process and speed post be filed. Ordinary process को कुछ तो नहीं जाएगा, खाली speed post होगा.
Exhibit 3 वाला भी relevant है. Exhibit 3 में
File ऐसा नहीं, जरूरत नहीं.
that is the rent assessment. Exhibit
Be filed within 15 days. Be filed by 22nd December, by December 12th. What are the records from the concerned court? Post on 23rd.
I had occasion to examine the purport of section 90 of the Chotar Nagpur Tenancy Act. When a khatiyar is published, then the remedy available is 87, that too within the 3 months. If that remedy is not availed, then under 5 years section 90 contemplates that it is the DT commissioner who has a right only to clear bona fide and material.
जहाँ टाइटल का डिस्प्यूट होगा ना, वो लोग नहीं कर सकते.
इसमें इस तरीके से नहीं हो सकता.
जबकि वो सेक्शन 87 में दिया भी हुआ कि टाइटल भी होगा, लेकिन वो तो बहुत ही प्रिलिमिनरी स्टेज.
हालांकि तो जजमेंट हम लोग का आया था ऐसा आ गया, उसमें हम लोग उसको रिव्यू भी फाइल किया तो नहीं हुआ. मेरा अपना हम लोग का मेरा अपना पर्सनल ओपिनियन है. नहीं आपका हमारा पर्सनल ओपिनियन है कि छोटा नागपुर टेनेंसी एक्ट में इसमें टाइटल नहीं दे. हालांकि डबल ई में है, उसमें 87 डबल ई में है.
डबल ई में है. आई थिंक वो कुछ ऐसे प्रिलिमिनरी स्टेजेस का कुछ होगा जब ज्यादा डिस्प्यूट नहीं है ये सब को लेकर. अदरवाइज तो टाइटल डिस्प्यूट
अगर ऐसा
दैट इज व्हाई 87 में जब बात भी हो जाता है
जी
टाइटल सूट इज मेंटेनेबल.
और इसका अदरवाइज भी अगर हम इसमें कहें कि अगर रेवेन्यू कोर्ट ही डिसाइड कर सकता है, इतना बड़ा सिविल कोर्ट का हम लोग को जरूरत ही क्या है?
नहीं, इट्स इन लॉ परमिट्स रेवेन्यू कोर्ट टू डिसाइड सर्टेन थिंग्स.
कॉम्प्लिकेटेड इशू ऑफ टाइटल नहीं कर सकते.
जजमेंट में क्या नाम है जो बोला है
परितोष मैती का जजमेंट है.
हाँ.
87 BLR में रिपोर्टेड जजमेंट है कि आप डिक्लेरेशन ऑफ टाइटल ला सकते हैं.
डिक्लेरेशन ऑफ टाइटल के लिए स्टिल द सूट वुड लाइक.
यस कोई 258 का बात नहीं.
हां 258
का बात नहीं. वो बहुत हम लोग के अपना हाई कोर्ट का फुल बेंच का जजमेंट. और दैट जजमेंट
that has conferred lot of power to the civil court to decide these
Yes.
kind of contested matters.
258 का बार is not absolute. In appropriate cases, the court can go into the details and a declaration of title is possible. Yes.
Item 23, second field 247 of 2023.
Is applicant?
Yes. Will you declare to the defendant applicant?
Lost in both the courts. What is your claim? It's a self-accord problem.
Plaintiff has filed the suit for declaration of half share and partition of the land. On the basis of saying that in the parcha, although we have exhibited those documents, parcha and exhibit A, parcha, exhibit B, is the order of the commissioner.
For what? पर्चा से आपका पार्टीशन को लिखने से
नहीं, हम पार्टीशन के लिए वो पार्टीशन चाह रहे हैं। तो
आपका क्या केस आप बताइए।
हमारा केस है
भाई है आपका कि
नहीं भाई नहीं
कौन
ये एक्चुअली land was recorded in the name of Sriram Kisku and Dhanu Kisku. They are the RT.
Okay, but they are not related to each other.
They are related, but in the parcha itself, separate dakhal kyari has already been mentioned in 1932, and prior to 1932, 1914, some dispute has been arose, and in said dispute, my learned commissioner has corrected the parcha in favor of this petitioner. Now they have filed suit.
Corrected the parcha.
You corrected the parcha.
The entire property was recorded in your name.
Some plots number 3500, 778, 160. ये प्लॉट में करेक्शन करने का आदेश दे दिया।
क्या किसका करेक्शन?
करेक्शन इन जैसे दो।
So the entire suit property, as per the order of the commissioner, is recorded in your name, exclusively.
Exclusively.
Entire
property. But they have make out a case that in pursuant to the parcha, Ganjar parcha, where he has said that some persons are mentioned dakhal kyari as my name and his name also, and some person are ijmal.
Yes.
Ijmal. That is their content.
ijmal रहेगा तो partition तो होगा ही ना.
इजमाल रहेगा तो पार्टीशन होगा, बट मतलब ये 1914 में वो एसडीओ के यहाँ ये प्रेयर किए थे, उसके बाद
क्या हो गया? 1914 क्या हुआ? 200 साल बीत जाने के बाद भी पार्टीशन जॉइंट फैमिली प्रॉपर्टी का पार्टीशन तो
जॉइंट में हम है ही नहीं ना, हमारा तो सकल उसमें इसमें ये भी आया है, इशू नंबर 4 में ही क्लियर है कि जैसे plaintiff are the owner of the father and grandfather and the defendant are the owner of the father and grandfather. Separate dakhal kyari का मतलब है कि they are separate possession, separate सब चीज कर।
पूरा प्रॉपर्टी का सेपरेट हो गया है। The entire property has been separated and recorded.
Some property which was
if some property is Ismail, then under such circumstances it cannot be said that there has been a partition by means of money.
But the unity of title matter.
Let's say unity of title, Ismail का property में तो unity of title and possession होगा ही ना?
इसीलिए proper appreciation of exhibit A and B has not taken into consideration by the both the court below. That is
exhibit. Okay. Exhibit A का क्या? What is exhibit A?
Exhibit A is a parcha where it is separately mentioned the recorded settlement.
Such the parcha
of Ganjar settlement 1932.
1932. Entire property has been shown separately.
सबका अलग-अलग दखल क्यारी लिखा हुआ।
आपको जो सवाल पूछना है उतना। The entire property has been shown separately. The entire property has been shown separately.
उस पर फंडिंग भी नहीं है।
बहुत अच्छा है। जो कोर्ट आपका आर्गुमेंट है, दो आपका एग्जिबिट ए एंड बी में आपका आर्गुमेंट।
हाँ।
आपको यही नहीं पता एग्जिबिट ए में क्या डिस्कशन दिखाई एग्जिबिट में। Show me the discussion of exhibit A. Page number 15 है। Page number 14 है।
14.
But that cannot be based on mere entries in the revenue records. Page number 14 of appellate court's judgment.
Appellate court. Page number 14 का नहीं होगा ये।
Page number 14, internal page 14 of appellate court's judgment. Still, there are certain lands which are shown as joint in Exhibit A, which means to show that they were not separated and whatever entries have been made in Exhibit was really cultivating possession of the respective parties. आपने रेंज भी जॉइंटनेस में रखी है।
इजमाल वाले के जो
सर आपने रेंज भी जॉइंट पे
ये क्लियर नहीं है कि कौन सा प्लॉट
नहीं ऐसे नहीं।
देखो इशू नंबर 4 ट्राई करो।
ये क्या नाम है इन दोनों किस्मों का? श्रीराम किस्मू एंड भानु किस्मू। How are they related to each other?
एक्चुअली जीनोलॉजी ऐसा है कि धानु किस्मू के पिता कुमार किस्मू और श्रीराम किस्मू के पिता बुधारी किस्मू, और ये कुमार किस्मू और बुधारी किस्मू के पिता श्रीराम किस्मू। आरटी है
भानु किस्मू एंड श्रीराम किस्मू।
हाँ,
भानु किस्मू के फादर का क्या नाम है?
भानु किस्मू के फादर कुनार किस्मू।
कुनार।
हाँ, कुनार KUNWAR।
और श्रीराम किस्मू
बुधारी किस्मू।
बुधारी।
हाँ, BUDHAR बुधारी किस्मू।
And how are this Kumar Kishku and Budari Kishku related?
ये श्रीराम किस्मू के बेटा है।
भाई श्रीराम किशकू के पिताजी का नाम तो बुधारी किशकू बताया ना।
हाँ, तो ये
कुमार
किशकू और बुधारी किशकू के पिता श्रीराम माझी है। माझी
वो भी श्रीराम
माझी।
तो they are brothers.
हाँ, they
are full brothers.
They are Kunar and Budhari full brothers.
Full brothers. और जो प्लेंटिव्स हैं वो किसके डिसेंडेंट्स हैं?
प्लेंटिव है धानु किस्कू का डिसेंडेंट।
धानु किस्कू। Okay. The line pass for Dapila has submitted that the plaintiffs are descendants of Dhanu Kishku and descendants of Dhanu Kishku and defendants are descendants of Shriram Kishku. The father of Dhanu Kishku was Kumar Kishku and that of Shriram Kishku was
Budhari Kishku.
Budhari, BUDHAR Kishku, and they were full brothers. Their father being Shriram Manji.
Shriram.
अब बताइए क्या दिखाना चाह रहे हैं? ट्राई कोड करता है।
मेन इशू इसमें है इशू नंबर 4. Issue number 4. Is there any unity between both the parties for right, title, interest and possession so land mentioned in the plan? यहाँ पर पेज 24 का second paragraph में the entries of in the Mr. Ganja settlement also contain reference issue number 4 madam. Sorry, 6. Paragraph 16. This issue is taken up at the first instance prior to other very much determination over the same shall decide the entitlement of the plaintiff with respect of relief sought by them. In the case of the plaintiff with regard to the unity of right, title and possession over the suit property is that the parties to the suit are still in jointness but are in separate cultivating possession as per their convenience. It has further been the case of plaintiff that partition amongst the parties are yet to be taken place on wills and bonds, but in contrary to the defense, defendant in separation of parties on the basis of entries being made in Ganges settlement. It has further been the case of defendant that recorded tenant got themselves separated in mess as well as residence, on the basis of which the entries had been made in the last settlement survey, and the parties to the instrument suit are coming in exclusive possession over their share, though their ancestral as per inheritance. Thus, from the country contention raised by the parties, one of the foremost document which is relevant for determination of the case is certified copy of Khatiyan of Jamabandi number 42, Modia Such, which has been marked as Exhibit A, is a admitted document. The original internet print out being available on the government website has also been filed, pertaining to which no objection has been raised by other parties. It is manifestly clear that internet print of Exhibit A, that is a Jamabandi number 42, certain portion of land have been shown as in exclusive possession of Sri Ram School, whereas some have been shown in exclusive possession of Bhanu School. Khesra number 1309 and measuring 19 kattha along with some other land had still been shown in joint possession in parties, and in remark column the entries been made in Ijmal board. The entries of Mr. Ganger's settlement also contain reference about the order passed by Commissioner Exhibit B is the certified copy of the order dated 2/10/1924 passed by Commissioner Bhagalpur in Santhalpurna Division Appeal number such and such, which is going to show that Learned Commissioner by order so passed has directed the authority to make correction in the entries, has set aside the order passed by ST. The legal question has been involved in this instant case is that whether the suit property being Jamabandi number such and such, Ganges settlement prepared from MacPherson Youth number such and such are joint between Siram Kisku and Dhamu Kisku or not. As far as the country contention being raised by the parties, though pleading and admitted position is that both the parties are governed by Santhal customary law in the matter of inheritance of succession and genealogy so given by plaintiff has duly been admitted by defendant. It is settled principle of law being laid down by apex court in the case of so and so. Thereafter, my lord, thus from the observation held by Honorable Apex Court, it is manifestly clear mere possession of the land and entry made in revenue record and exclusive possessor of any particular portion of the land will not infer that actual partition or meets and bounds have been taken place. Further, with regard to the status of the party within whose name some joint property has been recorded in revenue record and the parties are in cultivating possession of the land as like in the instant case has been elaborately discussed by Honorable Patna High Court.
So, political the council engagement in the document. This appeal has been filed against the judgment dated 17/2022. We will active decree passed on 14/8/2022 in signatory number 24 of 2020 passed by the district judge Honorable Yonka, whereby the appeal has been dismissed. The suit was that the tribal judgment has been passed in that partition suit number 65 of 2011. The bracket dated 21/12/2019. Bracket was passed by the senior division judge 2 Tunka. Thereby, preliminary decree of half share has been passed on contest. the Council for Document has submitted that the properties were shown in separate possession in gangsters settlement in Pacha as that as in the 1992 by Exhibit A, and there was also an order of Commissioner Exhibit B, which was also recorded in the gangster settlement. He says that there was a previous partition, and therefore there was no question of question. He has also submitted that issue number 4 was the core issue involved in this case. Issue number 6. Issue number 6 was the core issue. Issue number 6 was the core issue involved in this case. The genealogy and the relationship between the parties is not in dispute.
Part of the genealogy is denied in the written statement. मतलब that वो जो ऊपर में जो बोल रहे हैं कि दो आदमी एक्चुअली ये यहाँ कुनवार बुधारी तक ठीक है, श्रीराम मांझी तक ठीक है। श्रीराम मांझी का वो बता रहे हैं कि दो को भाई था, इशूलेस था, वो हम नहीं।
तो उसका कोई मतलब the material portion of the genealogy is not in dispute. After hearing the learned counsel for the appellant, this court finds that the specific case of the plaintiff was that there was unity of right title and interest, right title interest in possession of personal property, and parties were still in jointness, but were separately separate cultivating possession as per their convenience, and there has never been partition or leasing bond. On the contrary, the case of the defendants was that there was separation of parties, and such claim was raised on the basis of entries made in the gangster settlement. It was also asserted by the defendant that they got themselves separated in mess as well as residence, on the basis of which the entries were made in the service settlement, and parties were in exclusive possession of their share with respect to the ancestral property through inheritance. This court finds that the entire court considered the specific case of the defendants, which was primarily based on Exhibit A and B, and observed that as per Exhibit A, certain properties, certain portion of land was shown in exclusive possession of Sriram Kishku, whereas some were shown in exclusive possession of Bhanu Kishku, and some land were shown in joint possession of the parties. And in the remarks column, the entries were made in Ismail of both. It is not in dispute that Ismail means joint possession. It was also observed that the entries in gangster settlement also contained the reference of the order passed by the Commissioner, Exhibit B, which was a certified copy of the order dated 2/10/1924 passed by Commissioner Bhagalpur in Singhal Patna Division Appeal number 30 of 1924/25, which showed that the Commissioner had directed the authorities to make correction in the entries the trial court took into consideration the judgment passed by the apex court and also the judgment passed by the Patna High Court, and ultimately observed that it has been held by mere possession of land and the entry made in recorded rights as exclusive possessor of any particular portion of land will not infer active partition by using law. Further, the status of the parties within whose names and joint properties are also recorded in the revenue records. By referring to Exhibit A, the learned court recorded that certain lands were shown as joint between Sriram Vishnu and Manu Vishnu in a registered settlement, which showed that they were not separated. The court also observed that jointness of Sriram and Manu Vishnu could also be inferred from payment of rent in jointness. That is to say that rent pertaining to the entire Jamabandi number 42 was still being paid through single rent receipt, and both the parties had admitted that they were paying the rent jointly. Ultimately, the court held that the defendant reasonably failed to prove the previous partition between the parties and hence directed for partition and repeat the suit. The first appellate court has also considered the materials on record and have come to concurrent findings. The following manner. Now, the page number, enter the page 14 of the appellate court statute. It starts from Kaptibara, literally means possession by criminals. This court finds that there are concurrent findings recorded by both the courts based on materials on record that the defendant failed to prove previous partition between the parties, and therefore held that there was unity of right title interest in possession between the parties. This court finds this court is of the view that no substantial question of law is involved in this case, which is according to this.
Item 34, second appeal 72 of 2024.
This is a case judgment of reversal.
You are the plaintiff or the defendant?
We are the plaintiffs. They instituted a suit. Actually, the case of the plaintiffs were that the land was jointly purchased by two brothers, Abhi Singh and Mundra Singh. Plaintiff number one happens to be the wife, widow of Mundra Singh. Plaintiff number 2 and 3 happens to be his son. And defendants happens to be the son-in-law of other brother Abhi Singh. The case is that they are guided by their own customary law and provisions of Hindu law. Hindu Succession Act is not applicable because they are scheduled tribes.
Plaintiffs are the The land was recorded in the name of
Initially, it is in the name of Hari Singh and Bhandu Singh, both sons of Joy Singh.
Hari Singh and Bhandu,
Bhandu Singh, Bhandu Singh.
both sons of
Joy Singh.
Joyce. Plaintiffs are related to Hari
Yes,
Singh.
Lordship. Plaintiffs are related to Bhandu Singh.
Plaintiff number 1 is his wife.
No, Your Lordship. Bhandu Singh, then he inherited by Ram Singh, and thereafter Abhi Singh and Hundra Singh, they happens to be the sons of Ram Singh.
Ram Singh. And they have 2 sons.
Two sons.
Abhi and
Hundra Singh.
Hundra.
Hundra. H-O-N-D-R-A.
D-R-A. Okay.
Plaintiff number 1 happens to be the widow of Hundra Singh. And plaintiff number 2 and 3 happens to be his sons.
Son of Hundra.
Hundra Singh.
Okay.
Defendants happens to be the sons-in-law of Abhi Singh, the other brother.
Sons-in-law.
Yes, sir. The case of the plaintiff
Yes.
is
He had no sons.
he had no sons. Three daughters who were married. Their name is also
Yes. So when counsel for the appellant has submitted that the suit for partition
no declaration that sale deed executed by widow.
just the counsel for the appellant submits that the suit was filed seeking a declaration that sale deed number 1834 dated 18/3/2009 was null and void and was liable to be cancelled. By the sale deed was executed by Khadu
Bala Singh.
Bala Singh in favor of defendant number 1, 2 and 3. He submits that the suit property was recorded in the name of Hari Singh and Bhandu Singh. Both were sons of Joy Singh. The plaintiffs are the descendants. The Bhandu, Ram Singh was son of Bhandu Singh, and Ram Singh had 2 sons, Abhi Singh and Hundra Singh. The plaintiffs are widow of Hundra Singh and sons of Hundra Singh. He submits that Abhi Singh did not have any son, but had 3 married daughters, and the defendants are the sons-in-law of the married daughters of Abhi Singh.
Sons-in-law Abhi Singh.
Okay, sons-in-law of Abhi Singh. The vendor of the property, namely Khadu Bala Singh, was descendant of,
Was the widow of Abhi Singh.
was the widow of Abhi Singh.
Abhi Singh.
He submits that the parties are governed by customary law.
Customary law and Hindu law is not applicable as
This
per.
customary law, which customary?
This is simply stated that they belong to scheduled tribe, and in the matter of succession, it is their custom which prevails, not the Hindu law.
Which
And
customary law? You have so many tribes in Jharkhand.
that has been stated. But that is not the issue. That is not the issue involved in this case.
You will see that. You say that they are not governed by Hindu law.
That is the admitted case of both the parties. Defendants have not denied that they are not governed by their customary law, and Hindu law is not applicable.
What customary law? Is Deputy Commissioner a party in this case?
No, yes. Defendant number 4. Deputy Commissioner is a party. In this case.
Okay. Did he file any written statement?
Written statement on behalf of deputy counsel is not.
So it's not an ethical fact that they are governed by this customary law, and as per such custom, they are excluded.
It has come that belongs to scheduled tribe governed by Sarna religion and Bhumij caste. So as per their custom, which is prevailing,
What is their
which-
custom? Has it been proved?
that aspect I'm not. Yesterday it was listed in the supplementary. I did not go through the
No,
entire.
nothing has been proved. On the face of it, nothing has been proved.
No, but both
They
the
are
courts.
excluding the daughters of the family without bringing on record the customs.
I'm saying that both the courts below have come to the conclusion that they are governed by their customary law, and in that custom, widow and the married daughter do not have any rights. This has not been.
Where is the finding? Show me. You say that both the courts have come to a finding.
Yes, Your Lordship.
That they are excluded.
Appellate court finding, Your Lordship.
First, let me see the trial.
Trial court. Issues are at page number.
What is the issue that issue which covers this?
Issue number 5.
Issue number 5 is on the
Whether the
legality.
salary is executed by the vendor handled
Yes, issue number 6.
says.
What is the finding on issue number 6?
This starts from page number 56. And is
Issue number 6.
starts from 5, 6, 7. One has been taken together. It starts from page number 56. And it said,
On the analysis of pleading, they are governed by their own customary law
yes,
in the matter of succession and inheritance and are not guided by you. So, fair enough.
so whether the Khandugata Singh such and such is decided. And this finding
No,
of
just, this finding has been reversed.
no, that has also been upheld by the appellate court. Appellate court makes out a new case that although the said deed is null and void, but it is admitted case of the parties that the possession has been delivered to the
Just,
defendants.
So the same deed has been actually
Invalid by the trial.
by the time.
By the trial.
What happened in the first happened?
The first affidavit also states that Khandubala Singh did not have any right to transfer the land in favor of the defendant, but it says that since it is an admitted case that possession of the property has been handed over to the defendants, and we have not claimed any relief for claiming recovery of possession. So this suit is barred by Section 24 of the Specific Relief Act. Although it was never the case of any of the parties that possession has been handed over to the defendants, we contend that we are in possession. Defendant also stated that they are in possession. No issue relating to possession has ever been framed, nor any evidence has been led to that effect. So, based on completely perverse finding, this judgment and decree has been reversed by the appellate.
So plaintiff is in the plaintiffs claim that they requested the defendants to allow them to cultivate portion of the suit property.
That is a permissive position that can be said. That cannot be said to be that they have been dispossessed. Question of recovery of possession will only arise if I have been dispossessed. If there is a permissive possession,
Even in case of permissive possession, they are speaking a tightly. And even in case of permissive possession, it
it
means
is
that
not a permissive possession. Also, it is a case of joint possession. They have come to us as a family member. They stayed there and they
the
have.
defendant number 1, 2 and 3 are not your family members.
Family members in the sense
They
that
are the purchasers of the property.
no. Abhishek and Mundra Singh, they are two brothers. We are the descendants of Mundra Singh. They happens to be the sons-in-law of Abhishek.
Oh, son, but they are not your family members. As per
Distinct.
customary law, otherwise they would have inherited the property. They are not your family members.
Not family members in the sense that they are the sons-in-law of Abhishek.
That's right. So you were not in possession is very clear.
No. We have stated, your Lordship may kindly see page number 43 of the
43
judgment.
and there.
43 of the judgment.
That Khanduwala Singh died about 2 years ago.
Yeah, go. And her Shraddh ceremony, all the friends and relatives, including 1, 2, and 3, got independent numbers 1, 2, and 3 got together at the house of the plaintiffs. And at that time, the defendant number 1, 2, and 3, along with other relatives, requested the plaintiff to allow the defendant number 1, 2, and 3 to stay at village Robertson for a few days. Then the plaintiffs keep the request of the defendants and allow them to stay here and allow the defendants 1, 2, and 3 to cultivate some portion of land friendly for 1 year.
That's it.
This
So
year,
your possession was handed over to them.
no, it was joint cultivation. That is what I am submitting.
It can't be joint, no, because they have no right over the property.
Thereafter, your Lordship may kindly come. Few lines thereafter. This year 2013, since 1 day of the month of August, the defendants are whispering here that they have purchased some portion of the land from the mother-in-law, Khanduwala Singh. Then the plaintiffs become astonished to hear this, and after obtaining the certified copy of the deed, they came to learn that on 12/9/2013, Khanduwala Singh has sold the scheduled land to defendant number 1, 2, and 3 in a step-3 manner by registered sale-deed number such and such, without prior consent from plaintiffs, who are co-sharers of Khanduwala Singh. Neither Khanduwala Singh has any right to sell the scheduled land, nor possession of the scheduled land has been delivered to
No,
defendant.
naturally, because of this reason. Otherwise, it is your case that it was they entered in upon the property.
No, they were only cultivating for
Whatever
some
it
time,
is, but
and they
were
belong
in
to some
possession.
other village.
They were in possession of the property.
But this was-
Whatever be their status. So when you are seeking as per section 34, right? In case when you are not in possession of the property, and if you do not claim recovery of possession, the suit is not made.
It is not a case of we being dispossessed. This is a case that Khanduwala Singh was jointly possessing this land. After her death, they had come as a family member,
No.
not as an
You can't
outside.
have it both ways. They are outsiders of your family because they are not entitled to inherit the property.
They are not
They are an outsider as per customary law.
allowing somebody to cultivate land for 1 year does not.
Even in that circumstance, you are not in possession of the property.
It is not that entire possession has been handed over to them for cultivation. It is the case that some portion of they also cultivated. That is what, and no issue has been framed. Neither defendant claimed that we have been plaintiffs have been dispossessed and they are in exclusive possession of the land. That is not the case of the defendant. That's why no issue has been framed on the point of possession. Neither any point of determination by the appellate court. All of a sudden, a fresh case has been made.
Issue has been framed whether the suit is barred by the provision of specific leave. How do you say issue has not been framed? There is a specific issue to that effect. That the suit was barred by
Related to possession, that they are in possession and we are not in possession.
No.
And
The question of taking an issue on specific
But that was-
fact arises only when your belief is not in terms of the provisions of section 13.
but specific pleading was not there. It is only that whether the suit is barred by estoppel, waiver, acquiescence, and under the provisions of CLT Act and specific relief Act.
That's-
That was the issue. But there is no specific pleading to that effect that they have been given possession over the land in question and we are not in possession over any portion of the land. That is not there anywhere in the entire pleading of the party. And we have stated it has been said that it is an admitted case. It is not an admitted case because in page number 43 clearly stated that nor possession of the scheduled land has been delivered to defendant number 1, 2, and 3. So on our pleading, this judgment has been passed. Although we have clearly stated that position has not been handed over.
Or the council meeting on behalf of the Learning Council for the Abhiman submitted that there are concrete findings recorded by both the courts that the parties are governed by customary law and Indian law has no applicability. The seventh said that under the customary law, the daughters do not inherit the property and therefore sale by widow of Abhi,
Widow of Avish.
Abhi Singh to son-in-law, two or three son-in-laws was void and illegal. That is that the suit was decreed, but the first appellate court has reversed the finding. On the ground that the suit was barred by the provisions of Section 4 of the Special Duty Act. As plaintiffs did not seek recovery of possession from defendant number 1, 2, and 3, who were the son-in-law of Abhi. The Learning Council submits that the case of the plaintiff was that the suit property was never delivered to defendant number 1, 2, and 3, and the plaintiffs were still in possession. And that the registered sale number 1854 dated 18/3/2009 executed by widow of Abhi Singh in favor of number 1, 2, and 3, her 3 son-in-laws was never acted upon. However, widow of Abhi Singh had expired 2 years prior to filing of the title search. यही आता है आर्गुमेंट सेंटेंस on the point of formation of the arguments concluded. small orders on 6th of January. This happened in one day. By the time I come to try and type it out, why and data पहले का कुछ लिखना है.
From daily list for admission, item 23, first April 180 of 2025.
Not need time to use matter. My children, I use matter now. Some medical emergencies, he is not present.
No time.
Yes.
You want to add it?
My senior.
Are you not ready? Fine, fine.
Yes, ma'am. Fine.
Ready? तैयारी करके एग्जाम खत्म हुई आज तक. Yeah, who are you? Plenty for dependent.
Plenty.
Okay. It is first April. The suit has been discussed. Specific.
Specific performance, yes, ma'am. Agreement date in 12/10/2008 in favor of the plaintiff.
Then what happened?
Agreement for the ma'am and इसमें जो डिपेंडेंट है उन्होंने हमारा एग्रीमेंट नहीं किया. रिमेनिंग अमाउंट जो था 77,51,000 का एग्रीमेंट था जो सेल डीड बना था. 20 लाख मैंने पे कर दिया था टैक्सेशन के लिए और जो भी इलेक्ट्रिसिटी बिल एंड ऑल मैंने पे कर दिया था थ्रू द डीडी. बट इन्होंने टिल नॉट डेट मैम अभी तक इन्होंने रजिस्ट्रेशन किया है ना. उन्होंने मुझे सेल डीड कंप्लीट किया है इन्होंने ना एग्रीमेंट कंप्लीट किया. और इन्होंने ये चीज़ बोला कि न्यूज़पेपर में एडवर्टाइजमेंट दे दिया है कि हमारे भी जो एग्रीमेंट था वो खत्म हो चुका है. इस न्यूज़पेपर के बारे में मुझे पता भी नहीं है, मेरे नॉलेज में भी नहीं है मैम.
पहले डेट की समझ लीजिए जो फर्स्ट अपील होता है. If it is a contested judgment, as a matter of right, I agree to that. Okay, but I just grabbed it. Okay. The specific relief act का section 16 and 18. Okay. Every 180 or 25. आपका नाम बताइए.
सवाल.
Council for Dapina, MS Sabari is present. Issue notice to the respondents. Bihar. Unless we post for the requisites we filed by 22nd of December. Pose this case on 24th of February. 24th February. This is Sunday. Pose this case on 28th of January. Office to tax papers will be call for the records. They will always come. Concentrate with that. Please tell them. Please tell them.
Item 24, first April 181 of 2025.
college requisite. We filed by 22nd of December. Great. Who's supposed to? That the records be called on the concerned board. Since the customer applicant is absent, let a soft copy of this order be communicated to the constitution. So order review, applicant present is now unsent. Date for the same.
For hearing under order 41/11 from the evening 7:25, second appeal 538 of 2016.
In this appeal, there was one issue that one of the defendant died during pendency of the suit. And for that, one idea I have filed 150904/2025, including this legal representative of deceased responding number 80.
You are the plaintiff or the defendant?
The defendant before the court
And the person who died was?
was one of the defendant number 30.
How is it related?
She is not related to this. She is also party in this suit.
She was part of
And-
the first appeal?
Yes, and I have examined the record on the last occasion. Against her, neither any specific order of ex parte hearing, nor there is finding that notice was served upon. That was the position, and that's why your ladies was pleased to ask me to hold that without hearing the legal representative of deceased defendant, I will not.
Notice has been issued or silent?
No. Paragraph 12, I have stated the name of the legal representatives.
You are representing whom? Whom are you representing? Sorry?
Mr. Sabasati Thakur, he is on this.
Respondent appear हो चुके हैं?
नहीं, एक अपियर की है only. दो अपियर के हमारे एक सब्यसाची मुखर्जी on behalf of contesting defendant, respondent, and Mr. Pratik Sen, he is supporting the case of this applicant. And I have
Sabasati Mukherjee is representing whom? Respondent number? He is representing respondent number? कौन है contesting respondent?
contesting the respondent number 1.
Case number 550/2016. IA number 15904 of 2025. Asked for the applicant and submitted that the integrity application has been filed seeking addition of party. Serving that Hazrat Khatun, who is responding to in the present case, was defendant number?
Defendant number 30.
Defendant number 13.
No, defendant number 18.
Are you sure?
Yes.
Was defendant number 18 before the learned tribunal? Is submits that she expired on 21/12/1999 but was never substituted. He has also submitted that the proceeding was never set ex parte against defendant number 18 which suggests that the procedure regarding service of notice upon defendant number 18 was not complete. You were the applicant for the appellate court.
Yes.
The learned counsel for the applicant has submitted that the applicant was co-defendant. You were the plaintiff.
No, I was put.
The present applicant was co-defendant in the suit and then filed the appeal before the learned first appellate court. देखो party बनाया in which she was also made party. तो फर्क हुआ था notice. But he is not aware as to whether the notice was served upon Hazra Khatun before the learned first appellate court.
Lordship, he is appearing on this one.
Please. Submit that notice issued upon the proposed legal years and successors of respondent number 13. Are you present in respondent number 13?
Well,
How many respondents are appearing? 12 is appearing. Are you 5 वकालतनामा? 5 वकालतनामा or not 5 वकालतनामा? 5 और आप बताइए आप किनकी तरफ से हैं? आप इनके साथ हैं? आप इनकी तरफ से?
Respondent number 19,
99,
19 to 21.
19 to 21. The counsel for the respondent number 12. Mr. नाम बताइए.
आकाश कुमार.
आकाश कुमार. 5 वकालतनामा. During the court proceedings. Accordingly, it is taken on record. Issue notice to the proposed legal years and successors of Hazra Khatun, respondent number 13, ID number 15904 of
He is appearing.
13.
हाँ हाजरा के ही लीगल है.
तो respondent number 13 लिखे हैं हाजरा खातून.
जी.
तो आप बोलते हैं respondent number 12 की तरफ से आप
टीम की तरफ से हो रहे हैं.
कुछ नहीं पता किसका वकालतनामा हाथ में लेके खड़े मुझे से भी बुरा हाल है. किसकी तरफ से क्या फाइट कर रहे हैं? respondent number 12 लिखे हैं.
लिखो मैडम. 12.
13 का बात कर रहे हैं. 12 का वकालतनामा और आप भी जो है कुछ आपको नहीं पता. हाजरा खातून तो respondent number 13 है ना, उनकी तरफ से कहाँ फाइट कर रहे हैं? respondent number 12 इससे तो कुछ हाजरा खातून का पता भी नहीं चलता.
हाजरा इज इट.
जालो मिस्त्री के
किसका वकालतनामा फाइल कर? दिखाइए सर इनको दिखाइए. आपको तो कुछ समझ नहीं है. आपकी कौन सी है? Who is your senior? Who is is your senior?
He is.
Oh. किसका वकालतनामा आप फाइल कर रहे हैं?
सरफराज अहमद एंड सलमा।
तो आप रेस्पोंडेंट नंबर क्या लिखे हैं? किसकी तरफ से वकालतनामा फाइल कर रहे हैं?
I am not fine. He is fine. I have already appeared.
You are representing whom? Respondent number?
3, 4, 5 lordship. I have already filed
किसकी
lordship.
तरफ से वकालतनामा फाइल? 3, 4, 5. Are you sure?
Lordship.
Mr. Sabyasachi DT appears on behalf of respondent number 3, 4 and 5. और ये किसका वकालतनामा लिखे हैं?
13 के तरफ।
13 तो मर गए हैं।
हाँ, उसके जो लीगल हेड्स हैं लॉर्डशिप,
उनके लीगल हेड्स का नाम इसे एक सरफराज है, भोला खातून है। दो ही लीगल हेड्स हैं। और कितना नाम लिखे हैं इसमें?
दो ही।
सरफराज भोली
और भोली। आपको बिना नोटिस हुए आप कैसे? हम तो पुलिस स्टेशन से पूछेंगे। अभी ना पढ़े। आज तक आपको नोटिस नहीं हुआ और आप अपने से वकालतनामा लेके यहाँ पे खड़े हैं। I have my doubts। क्या आप किस कौन वकालतनामा दिया? Who has given you this वकालतनामा?
They have proceed their signature lordship because I asked to the client that why they have never appeared. So my client went to the house of this person's lordship.
Okay.
Then they said that they are not at all relevant. They have no interest in this case. But my clients said that because of your appearance, this case is pending. Thereafter, they have given their wakalatnama and they have stated that they have no interest in this
Thereafter, they have
case.
given the wakalatnama to
Lordship. Not we. To the client's lordship, thereafter,
So
they have given.
they are gained over. Apparently, they are gained over.
Not at all, lordship. That's why
If
they never
plaintiff is
appeared.
contesting not only against me but also against all the defendants.
Your lordship, when they have no interest, they do not want to contest the case.
So they,
But only
I want
because
to know 99 से बढ़ने के बाद कुछ नहीं है केस के बारे में।
your lordship.
ठीक है? अब suddenly he is appearing with the वकालतनामा। इसमें अभी तक नोटिस भी नहीं हुआ।
Notice your lordship, but because your lordship, my client went to them that only because your non-appearance before the suit, this case is pending. Thereafter, they said that we don't have any interest, but only because of our appearance, this case is pending.
आप एक चीज उनसे पूछिएगा आपको वकालतनामा किसने दिया?
क्लाइंट लगा थ्रू क्लाइंट
Who came to you? Are you sure? उनका आधार कार्ड लेके। आधार कार्ड के साथ वकालतनामा करेंगे।
ओके
Right? Issue notice to the proposed legal heirs and respondents of Hazra Khatun, whose details have been mentioned in paragraph 12 of the regulatory application. Mr. नाम बताइए अपना नाम
आकाश कुमार
Mr. Akash Kumar submits that he is holding wakalatnama on behalf of the proposed legal heirs and successors of Hazra Khatun, but he is directed to file a wakalatnama along with an affidavit annexing the Aadhaar card of the proposed legal heirs and successors. And also clarify their stand with respect to the present issues. It is the argument of the appellant that Hazra Khatun, having died on 21/12/1999 during the pendency of the suit, the entire proceeding is vitiated. अब आप जवाब समझ आ रहा है आपको बात? आप भी फाइल करते हैं। On this aspect of the matter, the counsel for respond number 1 to 3, 1 to
2, 3, 4.
2, 3, 4 may also file their response. Who is for respond number 1? Respond number 1 की तरफ से कौन? किसी का वकालतनामा है? अब्दुल जलील वगैरह का तो वकालतनामा आपकी है फाइल की तरफ से, राइट? लेकिन उसमें अब्दुल जलील का भी वकालतनामा जिनका सब्स्टिट्यूशन हो गया 2023, तो उसके बाद उनका वकालतनामा फाइल किए
उसके बाद में उसका भी फाइल करा देते हैं।
उनका सब्स्टिट्यूशन हुआ है 2023। आप देख लीजिए रेस्पॉन्डेंट नंबर 1 का भी आपने वकालतनामा फाइल किया है। उनका सब्स्टिट्यूशन बिहेवियर का भी फाइल किया है। कुछ नहीं पता है, कुछ भी नहीं पता है। इतना 2016 से केस चल रहा है, आपको कुछ नहीं पता। कैजुअली आप को लेते हैं, किसका वकालतनामा होल्ड करते हैं वो ही नहीं पता किसको डिफेंड करना। Respondent number Sabasaki जी का appearance दिखाइएगा। Respondent number 1A1C 1A शहनाज वालों को लिख लेंगे। उसके बाद एक अमजद सलीम शहनाज वालों की तरफ से 1A and Amir Zafar 1B चार आदमी का वकालतनामा फाइल किया है और सब्स्टिट्यूशन से 3 आदमी का पता नहीं किसका वकालतनामा। एक ही आदमी छूट जाएगा ना, फिर आपका वही कहानी हो जाएगा।
कंट्रोल करना चाहिए था कि चार भाई हैं,
सब तो कोशिश करना चाहिए।
नहीं इन हम कह रहे हैं कि जो एपियर कर रहे हैं वो कहेंगे ना कि हम तो 3 नहीं 4 हैं।
आपको बता रहे हैं, आप जानने चाहिए।
हम रिकॉर्ड करके हम रिकॉर्डिंग में सुनते हैं।
सब चाची अगर आपसे नहीं बैठता है ना, एक हाइकस अपॉइंट कर देते हैं आपके लिए। लेकिन प्लीज डू नॉट डू दिस टू योर लीगल। आई विल अपॉइंट एन हाइकस राइटर। नहीं आपको नहीं कुछ रेडी नहीं, आपको कुछ नहीं पता। क्या व्हाट हैव यू रेड द फाइल? यू डू नॉट नो किसका वकालतनामा फाइल किया, क्या फाइल पढ़ी? वकालतनामा का फोटोकॉपी भी नहीं रखते क्या आपके पास? या फाइल नहीं आया आज आपका घर से?
नहीं फाइल आया है
दिखाइए सर फाइल।
दूसरे कोर्ट में भी छूट गया
दूसरे
वहाँ
कोर्ट में फाइल रखा हुआ।
दौड़ के आए हैं नोट्स
Very good. Then I will appoint an amicus. No, I will not accept this in civil litigation. The English litigation. I need an amicus. वो आप लोगों को कुछ record का पता नहीं होता. I need an amicus in this case. I will appoint an amicus. आप नहीं करेंगे तो भी आपका case
Lordship, I have given judgment. I have put it
I
all
don't
the
bother
facts.
about it. You are standing
Only-
without. You don't feel ashamed. You are standing without a file. You do not know whom are you representing before this court.
Lordship, I know and I will verify from the.
Before, please come. ये आप लोग से नहीं निपटने वाले, आप लोग से नहीं होगा. It's a very important issue to be decided. A defendant was dead. कोई death certificate भी नहीं लगा. आप death certificate लगाइएगा defendant. Right? You should annex a copy of the death certificate of the defendant. जो भी है आपका, जिसको भी आप represent करना है. You get this? Considering the nature of dispute involved in this case, this suit is of the view that an amicus is required to be appointed to assist this court in the matter. Mr. Vibhor Naik is present in the court and the court has requested him to be an amicus in this matter, which he has readily accepted. The counsel for the appellant is directed to hand over the entire records of this case, a copy of the entire records of this case to the learned amicus. A copy of it. You can inspect the record anytime. Date the date. Now file report for this. No idea what to say. Office is directed to print the name of Mr. Vibhor Naik. किसी तरह से प्रिंट करेगा तो रीजन है इज जस्ट
इनको एक वायलेंस फॉर योर कन्वीनियंस काइंडली इनका प्लेंटिफ है मेनली प्लेंटिफ का ही केस था जो हम लोग तो कंटेस्टिंग डिफेंडेंट्स है तो फॉर प्लेंटिफ जो है वही पे करेंगे बस पॉइंट नंबर 1 प्लेंटिफ
अरे किसी को पेमेंट नहीं करना है
नहीं प्लेंटिफ हम वो बोल रहे हैं
नहीं ऐसा नहीं हम करेंगे प्लेंटिफ और डिफेंडेंट की तरफ से नहीं करेंगे आई नीड दिस असिस्टेंस
अच्छा टोटल इन दैट इशू की डेड पर्सन का केस पे
डेड पर्सन या व्हाटएवर द इशू आई नीड दिस असिस्टेंस 2016 से अभी तक किसी सब्सटेंशियल ऑफ लॉ नहीं बना है इतना कॉम्प्लिकेटेड हो रहा है सारा रिकॉर्ड को वेरीफाई करना भी इतना ये हमसे अकेले नहीं और आप लोग के लिए
हम लोग क्या करें
जो नहीं आप लोग मतलब जो भी लोग आके कर रहे हैं उनको नहीं पता किसका वकालतनामा है बिना नोटिस के वकालतनामा लेके खड़े हैं ये नहीं पता कि कौन है
हम लोग क्या
99 में जो आदमी मर गया ना उसका लीगल केयर का वकालतनामा लेकर आदमी यहाँ खड़ा होकर तो हमको बहुत सीरियस डाउट होता है बिना नोटिस के वकालतनामा लेके यहाँ खड़े
बिल्कुल वही तो इसलिए तो आपने थ्रू पुलिस स्टेशन नोटिस किया
पुलिस स्टेशन
ओ नहीं एफिडेविट फाइल कर नहीं भी ट्राई कर सकते
his name should appear on the side of the response.
ठीक
उसका नाइट ये सिस्टम रखे ही इसी आपका नाम नहीं है भी बोल रहे हैं इसमें और कहते सीने हो गए हाँ आपने तो नाम नहीं दिया है You are not interested?
No, I am. From supplementary list order we defect item 1, second appeal 87 of 2023.
Yes, defective petitions.
4 weeks time. 4 weeks.
4 weeks. Stand till 30th January. 26 is granted to the applicant to remove the surviving today or to file an application in the application and one of them. Post from 7 to the campaign. 16 फरवरी से
Item 2, second appeal 88 of 1023.
weeks still or
आपने देखा है ना डिफेक्ट?
हाँ देखा है एक्चुअली ये मैंने डिफेक्ट रिमूव कर दिया था वो इसमें कुछ डिफेक्ट्स थे क्योंकि ट्रायल कोर्ट और एप्लीट कोर्ट का दोनों में डिफर हो रहा था गया था नीचे कोर्ट में करेक्शन हो गया उसके फिर टेक्निकली वो निकाले हैं तो
Item 3, second appeal 208 of 1023.
In course of there is a minor correction. Minor judgment and decree का clear portion लिखना छूट गया उसको नहीं कर
ऐसे नंबर 208 of 23 also for Datina calculates remove the fix कब तक
अगला सप्ताह किसी दिन भी
at the first board this case on next Thursday again
Item 4, second appeal 224 of 1023.
it's 2 weeks to
same order 3 January and 30th January of 1920 and it will come up 18th September.
Item 5, second appeal 231 of 1023.
Same. 30
Item 6, second appeal 232 of 1023.
Same.
Item 7, second appeal 248 of 1023.
Praying for 6 weeks time.
Same. 30 January तक क्या हो गया ना
Item 8, second appeal 249 of 1023.
और भी डिफेक्ट्स हैं
और डिफेक्ट नहीं है टोटल क्लियर है
ऐसे नंबर 249 of 2023 also for the applicant submits that the surviving defect has been कब रखना है
रख दिया जाए नेक्स्ट में दिन रख दिया जाए
I just request the matter is eligible for the next day.
Item 9, second appeal 250 of 1023.
Lordship, may kindly see defect number 7, Lordship. The judgment and decree that
Item 9,
there are some defects. 2 weeks.
Same order.
Item 10, second appeal 55 of 1024.
Effect number 4 है इसमें अपलेट डिग्री में पीएस जो पीएस में रिस्पोंडेंट नंबर 3 का वो गलत हो गया है, जबकि जजमेंट में सही है और ट्रायल कोर्ट में भी सही है। तो वो विलेज महिया खुद पीओ पीएस महिया इसमें जजमेंट में है, जबकि डिग्री में हो गया 77 हो गया। 38 डिग्री जजमेंट है 70 पे। तो रेक्टिफाई या फिर भी छूट गया, रेक्टिफाई के लिए गया था लॉज में, फिर भी छूट गया वहाँ।
ऐसा तो कोई डिफेक्ट पॉइंट आउट नहीं किया है, तो आपको परेशानी
नहीं है ना, मुझे है डिफेक्ट, इसी के लिए लगा हुआ है डिफेक्ट नंबर 4 लगा हुआ है, प्लेस हुआ है। हाँ
has not given you
हाँ सेकंड हाँ इग्नोर कर दिया।
there is surviving defect in the region with the case name of respondent number 3 in the degree.
In the
degree passed by the learner was applicable. Service and the defects may be ignored for the present. And this can be taken care of in the acceptance.
Where is correct PS name is mentioned in the judgment?
There is correct PS name is mentioned in the judgment. Service that this defect can be taken care of if the second appeal is ultimately admitted. अगर एडमिट होगा तभी ना ऐसा कुछ नहीं बैठे।
हाँ
डिले भी तो है आपका।
हाँ डिले
क्या आपका एक्सप्लेनेशन
डिले तो
297
हाँ 297
क्या एक्सप्लेनेशन
डिले का तो कॉल यही है कि बोनाफाइड मिस्टेक कम्युनिकेशन गैप है, नहीं जानकारी हो पाई, आज जब एक्सक्यूशन प्रोसीडिंग इनिशिएट हुआ तब जानकारी नेक्स्ट पार्टी लेकिन ऑथोरिटीज को जानकारी नहीं थी। स्टेटेड राइट टू
posted on 28th of December. The question of issuance of notice on the litigation has been raised. We will still find some merit. लेकिन अगर लगेगा कुछ ऐसा
हाँ है क्वेश्चन ऑफ लॉ हम जो बनाए
और कोई
एक तो स्टे ऑफ एक्सक्यूशन है, तो अनलेस एंड अंटिल द अपील इज एडमिटेड एक्सक्यूशन का तो बात नहीं। हमने जो क्वेश्चन ऑफ लॉ बनाया whether in the absence of examination of plaintiff.
The litigation matter will also be considered on this. हम कुछ और भी मैटर रखते हैं। सोचे हैं कि सेकंड एप्पल में ऐसे नोटिस करने से क्या फायदा? तो मेरिट नहीं है जबरदस्ती लिमिटेशन के नोटिस।
हाँ नहीं मेरी लिमिटेशन मेरिट भी है।
Item 11 second April 60 of 2024.
What defect? 2 weeks time में wait.
Yeah, and just give again.
Item 12 second April 62 of 2024. Item 13 second April 63 of 2024.
Defect number several lots of mechanical lots. The earlier lots is judgment decree under appeal was sent to the learned court lots. But office has pointed out that the parentage of the respondent number 37 does not find place in the degree lot. The 36. I pray Lord the degree may be once again may be sent to the learned court lots for making necessary correction lots.
तो आपके रिकॉर्ड में होगा ना, जजमेंट में है ना?
जजमेंट में आज तो गलती से फाइल छूट गई है हमारा।
कोई बात नहीं, क्या नाम है रिस्पोंडेंट का?
क्या बोल रहा हूँ? जयदेव रावत। ये इसको इग्नोर कर दिया जाए।
जयदेव उनके पिताजी का नाम ही नहीं लिखा हुआ है तो क्या अपने कोर्ट के चार्जिंग में भी नहीं है
नहीं, एक बार गया था फिर छूट गया।
इसीलिए नहीं है क्योंकि आपका और सेटलमेंट नहीं होगा उनका नाम खाली रेजिडेंट ऑफ लिखा हुआ है फादर का नाम नहीं है
ट्रायल कोर्ट में
ट्रायल कोर्ट नहीं है डिग्री न अपनी इसीलिए आपको इसमें नहीं है सन ऑफ लीग के काटा इट इज नॉट अवेलेबल ट्रायल कोर्ट जब sons of Buttu of Raipur में है
उसी को लिख दे।
आपके हाथ से लिख सकते हैं
नहीं नहीं होता है ना, तब फिर करेक्शन नहीं।
आप इसे सही लिख रहे हैं
जिस
मेमो
सॉरी फाइल में छूट गया तो लॉस मेरी
ऐसे नंबर 63 और 24 The learning council program submitted that the DT was sent for correction by the learning post applicant. But the same, but there is still a defect in connection with respondent number 36, namely Jaidev Rao. Respondent number 36. With respect to respondent number 36, before the learning first upload. The appellate court's judgment. Who is respondent number 45 in the present case? Somebody said the appellate court's judgment does not record this father's name, but the learning first appellate court has recorded his father's name as late Jitula, which has been correctly mentioned in the memo. He submits that the defect in connection with the appellate decree being known for the present. And the question of its correction would be required only if the substantial question of law is framed in this. Considering the aforesaid, the defect in connection with the decree the aforesaid defect is ignored for the present. I will counsel for the applicant with the ability to remove other
सर्वाइविंग
surviving defects.
कुछ भी है एक 10 रुपए बाकी तो भी पे
इतना
कर
कुछ बाकी हैं सब और भी defects हैं.
दिक्कत नहीं
By 30th of January 20, post
जी।
18.
Item 14, second appeal 66 of 2024.
Same one.
Item 15, second appeal 69 of
Same
2024.
one.
Item 16,
Same one.
item 17,
Same one.
item 18,